magistrates in those matters for 30 days.
For your information, they never objected. The respondents never objected to that detention.
Your Honor, I'll make an application.
Yes,
the court either can respond. You allow me to make an application.
Yes,
I'm coming to that.
In that application, in fact,
Your Honor, could that be
just
the
1
ruling?
minute. In fact, the state was asking for 30 working days, which the respondents themselves agreed.
Your Honor,
but
could
as
that...
the court, just 1 minute, but as the court, not even as we submit, the state requested for 30 working days, which the respondents agreed, but even as the court diverted it back to 30 calendar days.
Could that be in the ruling as an answer to our application?
So the rest of them did not. No, just putting that into proper perspective because at least that one I have a knowledge of. Okay. No, I will come to you once he's through with the first respondent. I will come to you. But I was just putting that in proper perspective that application was completely unopposed. In fact, I even reduced the time the respondent themselves. Then we can proceed.
Let me proceed.
Can proceed. Yes.
Your Honor, let me proceed so that the court can give a reasoned ruling on all the issues that we raised.
Yes, proceed. That is to then number 3.
So we were saying, Your Honor, that the court has already made a definite decision, and that mind is already set. They are of great importance. There can never be two decisions from a same court where facts are the same, where the subject matter is the same. But this matter, court handling it now recuses itself, and another judicial officer will have the time to exercise his or her mind independent of other decisions. Your Honor, this is the norm in all courts, where the courts say, I have already made up my mind in this matter. Let another judge, let another court also make a mind on its own. Your Honor, lastly, I've only laying the grounds my colleagues should bring the facts and the law and the authorities on that. This court has denied the chance for our client Mr. Oroko.
No.
You are not the one.
Again. No, we have already made a decision on
I
that.
am not accusing
let's
the
not go
DPP.
to the issue of Aroko, please.
What I'm saying,
And the reason why I deliberately said the file for Aroko is so that in the system, bringing him here.
Your Honor,
Let's deal with this. If you want me to recuse myself in this, I make
it is one of the
Once you go to
reasons.
the Aroko file, if you want me to proceed, it's okay. Council kindly, let's not bring Aroko in this.
Your Honor, let us give our useless grounds.
Let's
Dismiss them by law.
Because Aroko's file is yes.
What I'm saying,
made a decision on that.
Your Honor, what I'm saying,
Yes. Please don't take us the part of Aroko.
let me not make an
If you
application.
want to talk a whole day about Aroko, we'll get to him.
Your Honor, let me not make an application that the state and the court are one and the same thing. This application is about recusal of a court. It is not about recusal of the DPP.
That is an allegation that is so grave. The state is the state and the court is the court.
It is very simple, Your Honor, that for him to make an application, before he mentions the name Morocco, you do not know what he's going to say next. Why don't you allow him to say what he's going to say? Goja.
The court had already
No.
made a decision on
You know what I'm going to say
Why
next?
bringing it up again?
Do you know what I'm going to
His
say
file
next?
is
I'm addressing the
separate.
court,
Dealt with
and I should not be
separately.
addressed by somebody from the side.
It should be dealt with separately.
Let him say what he wants to say. The moment he has said it and it is not in reason, you will ignore it or you will deal with it in the application and say it is not relevant.
My Honor,
That's what, Your Honor, so that the prosecutor does not stand up and keep on making noise as I'm talking.
I'm not making noise.
You should
I'm saying
agree
we'd
that
like
if he's
it
making
in
an
written.
application,
We'd like a written formal application.
then allow us to do it. We'll still do it.
I'm dealing with miscellaneous criminal application number E081 of 2025. Can we restrict ourselves?
No, but Your Honor, wait. Just let me say this. Your Honor, when we come to court in the morning, and when we reach here, we find that you have an application for Aroko. You're having the file. You start speaking about it. The prosecutor responds. The two of you just keep on conversing about it. You have been served. We are coming to this court about it, and we are not served. But you discuss and decide, can we consolidate, can we not consolidate, can the facts the same and all that. That means you have read it, we have not. And we are supposed to also, even for a moment, be told that this is what we are talking about, this is the application, so that we can also give a contribution. So the prosecution is telling you, no, let us have a different time, we can do it. The court is saying, no, the facts are same. Are we just coming to what? Isn't that bias? Isn't that
I think, I don't know whether we are seeing things from completely different perspectives.
Completely.
The reason why I mentioned file for Aroko is here is because I didn't want to be taken the part of Aroko today, the way I was taken the part of Aroko yesterday, who was not before court. So that we can distinguish issues and we deal with issues separately. That was my intention. So that once we get to Aroko, we deal with Aroko. Once we are dealing with this file, we deal with them. So that you not start telling me that Aroko has not been brought 24 hours have lapsed. So that issue